Mr. Winslow was also present. A couple of things to go over. We did shoot some emails back and forth over the weekend. I had sent a proposed jury instruction for 375 to council late Friday. I did receive an email from Ms. Barr last night or yesterday with a couple of briefs, and I received some more emails from Mr. Owens over the weekend as well. A couple things we need to discuss before the jury comes in. Mr. Carlos, which witnesses do you plan on calling this morning? Or Mr. Watkins?
Your Honor, we're going to be calling Officer Jacqueline Pacheco, Detective John Johnson, and Summer Foster.
Okay. All right. And those will take no more than a half hour, I assume, correct?
5 minutes at the most.
Okay. All right. Do you plan on having your client testifying?
No.
Okay. All right. Mr. Winslow, I need to tell you that the decision on whether to testify or not is your decision. Oh, you can remain seated. It's okay. Yeah. The decision to testify is your decision and your decision alone. Of course, you have excellent attorneys who have conducted the trial, and I would expect that you would discuss that with them, but the decision is ultimately yours. You have an absolute right to testify on your own behalf, and you also have an absolute constitutional right not to testify. If you do not testify, I will instruct the jury as follows. A defendant has an absolute constitutional right not to testify. He may rely on the state of the evidence and argue that the people have failed to prove the charges beyond a reasonable doubt. Do not consider for any reason at all the fact the defendant did not testify. Do not discuss that fact during your deliberations or let it influence your decision in any way. That's what I will tell the jury if you decide not to testify. So the decision is yours and yours alone. Have you had enough time to discuss this decision with your attorneys?
Yes, Your Honor.
And is it your decision alone not to testify?
Yeah, I'm not going to testify.
Oh, all right. Then I will instruct the jury according to the law which I just read to you. All right.
Yes, Your Honor.
Then we're going to be finished with the evidence shortly. What I will do then is I will instruct the jury after the completion of the evidence, and timing-wise, there's no possible way we can get the closing arguments in today without breaking them up. So I would propose that after I instruct the jury, in other words, I don't want to have Mr. Owens argue, the defense argue, and then have Mr. Owens argue tomorrow morning. I don't think that's a fair way of doing it. What I would propose is get everything done today in terms of taking the evidence, instructing a jury, and start first thing tomorrow morning right at 9 o'clock with argument. Is that acceptable to the people?
It is.
Acceptable to the defense?
Yes, sir.
All right. It will result in a short day, but there's no way we can get everything done in one day and have continuous closing arguments. All right, then, with respect to the exhibits, you had a chance to go over the exhibits over the weekend or late last Friday. Mr. Watkins and Ms. Barr, you have objections to 2 exhibits, is that correct?
Yes, Your Honor.
154 and 157.
Correct, as a hearsay.
All right. Mr. Owens, do you want to be heard?
Yes, and that was 154 and 157?
Yes, it's
the text message between
text messages
Jane Doe
between Jane Doe number 4.
Yes, Your Honor, I'm looking at them now.
I'm sorry?
I'm looking at them now. I think that the proper foundation has been laid. First of all, they constitute prior consistent statements that were made prior to the motive having attached, the motive to fabricate that has impliedly been brought forward by defense counsel in their cross-examination of Jane Doe number 4. This captures the exact language that was used during the communication she had with Nicole Edwards. She and Nicole Edwards spoke prior to Jane Doe number 4 coming forward and reporting the incident from 2003 to law enforcement. And it shows a consistent statement to what she testified to on the stand in this trial. I would also note that there was much made by defense counsel during cross-examination of Jane Doe number 4 regarding the specific language that was used and what she told Nikki and what Nikki then responded with, including the allegation that Nikki made the statement, let's get him or something to that effect. I think it was, gotta take him down. So I think that the fact that this captures the actual conversation, at least the beginning of it and then the end of it, I think it has been properly authenticated and comes in as a hearsay exceptional.
Okay. All right, anything further, Mr. Watkins?
Yes, Your Honor, we object. Those particular statements were not intact and were not impeached. And of course, Nikki's response definitely is hearsay. So we would maintain our objection that it's hearsay and it shouldn't come in.
All right, so it's your position that the statements are offered for the truth?
Absolutely. Other than that, they're irrelevant.
All right, well, some of these are not offered for the truth. For example, can you talk right now? Text me. I'm sitting here because I can't sleep. I think that the key here is that the statements were made and they formed a basis for a fresh complaint, and it would be admissible for that purpose. But there's a lot of other superfluous language in here that is duplicative and cumulative because it was brought out during the course of the trial. So the court will grant the motion to exclude 154 and 157. However, the content is present because they testified as to what was said. That also reduces any prejudice because you could cross-examine them. But it does constitute hearsay for the most part. We could go through and redact it, but that would then take the context away. So the court will grant the motion to exclude 154 and 157. All right, with respect to the remaining exhibits, there are a number of exhibits that have been marked but not received or identified. I've gone through the exhibit list, and there are also some that were marked and weren't used. We also have another exhibit, which is 182, I believe. 182. Okay, that was previously marked, but you marked another one, which is 183. And that's the Gofundme page?
Correct. There's two Gofundme pages exhibits. We did mark an additional one. The additional one does have her name on it, so it's a more full picture.
And that's 183.
That'd be the next one in order, 183.
All right. You've had a chance to go over the exhibits, Mr. Owens?
I have, and while I haven't tracked each one that's being withdrawn by defense counsel, if it hasn't been identified during the course of the testimony, then the people have no objection.
Okay, so let me go through the exhibits. All right, I'm inclined to receive the following exhibits and evidence. Exhibits 1, 2, 4 through 17, 20 through 49, 51 through 78, 79 through 85, 86 through 90, 91 through 99, 104 through 105, or just a moment here. 107, 111, 114, 117, 118, 120 through 132, 133 through 145, 148 through 159, 162 to 165, 168 to 171, and 172 to 181. Is there any objection to those, Mr. Owens?
No, Your Honor.
And by the defense?
Can we have one moment, Your Honor?
Yes. Okay.
To 88.
All right, and
and
what's the objection?
The objection is, well, the people, well, they did not provide any credible testimony regarding the location of where, you see there's a squiggle on there, on the
Right.
route, and I think their witness testified that that may have been the driveway of Jane Doe 3.
Correct.
But there's nothing that links it up. There's no map, there's no photo, there's no address, there's nothing other than just the little loop that comes off of Lake Drive.
All right.
And I think that's, without more, the actual diagram that's depicted there is prejudicial in that there's no testimony as to its accuracy. It's just a representation of a line.
Okay, so you object to 88 on those grounds?
Yes.
All right, I'm checking my trial notes, and on May 28th, Haley McKinney, the crime and intelligence analyst, testified that, I guess you'd call it a squiggly, but it's a line that shows that he was riding his bike, made a U-turn, and went in that area. Haley McKinley testified that is the location of Jane Doe number 4. Just a moment. 3, I'm sorry, Jane Doe number 3. And I noted that in my trial notes. She said that is, and that puts him in Jane Doe number 3's front yard.
Except she didn't.
Not on the date of the offense, it was earlier,
It was the day before.
the day before, which is consistent with her testimony that he had come by and,
But she did not testify that she was familiar with the location, that she actually saw the location physically. She just said that this is the area where this is the driveway or the area where she lives.
that's
but
exactly what she said.
nothing else though.
Right.
There's
Nothing
no
else is-
driveway depicted.
I'm sorry?
There's no driveway depicted.
Right, there's no driveway, but it's the location, and there's, you could argue that in closing, but that does not go to the admissibility, it would go to the weight, if anything. So the court will allow court exhibit number 88 over the objection of the defense, all right? And then any other objections to those documents or those items of evidence the court just read off, Mr. Owens?
No.
Any objection by the defense?
Just lastly, Your Honor, on that 88, and just for the record, it's clear, we object on foundational grounds.
Okay, understood. Other than 88, do you have any other objection to those exhibits which the court just read off?
No.
All right, then those exhibits will be received into evidence.
And Your Honor,
The-
confirming excluding
Right.
154 and 157 with the, in accordance with the court's ruling.
Right, the
Okay.
court did exclude those pictures that were extracted from the defendant's phone. Those are not
Thank you.
going in.
Thank you.
And also with respect to 85A, which is the transcript of the body worn camera, that is not being received. It will not go back into evidence, all right? Okay, then the last item we have to address are the jury instructions. We made a first pass at it last Friday. The court did tag a few of the instructions, one of which was 301. There was just a typo on that. Mr. Owens has submitted a new 301, so the court will give that. We had an issue with respect to 315 and eyewitness identification. Did the defense want to be heard on that? There were some questions of whether it needed to be given.
No, Your Honor, we didn't have a problem with that.
Okay, so I will give 315. With respect to 361, that's if the defendant failed to explain testimony or deny evidence against him, that's withdrawn, correct?
It is.
All right, since the defendant's not going to testify, 361 will be withdrawn. There is the jury instruction 375. The court emailed a jury instruction, the court's proposed jury instruction to counsel late Friday. And the court is not, the court indicated that I'm not inclined to allow that evidence for purposes of establishing whether the defendant had a reasonable and good faith belief in consent. All counsel received that email, I'm assuming, correct?
Yes, Your Honor.
Yes.
Okay. I cited the case of People versus Bruce at 208 Calat 3rd, 1099, which cautions against using 1101B evidence for this purpose. Are you still making that request, Mr. Owens?
I'm not making that request, Your Honor, and I think what's interesting about that case is that the issue was whether or not that evidence could be used for the defendant's actual belief that the victim consented in one rape case as opposed to whether it was reasonable. And we started having this discussion on Friday. I think that given the fact that Mr. Winslow has elected not to testify, that there is no need to request the instruction on reasonable belief in consent.
All right. There's also the issue of what burden of proof is required to allow the jury to consider such evidence. I did receive the brief yesterday afternoon from defense counsel suggesting that it could be structural error to instruct based on a preponderance of the evidence. I'm inclined to follow the suggestion that the prior acts need to be proved beyond a reasonable doubt, and also only allow it for the purpose of establishing the defendant's intent to kidnap with a specific intent to commit rape or forcible oral copulation, thereby allowing the jury to only to consider counts 4 and 5 as evidence of his specific intent for count 1. So do the people have any objection to that?
No, submitted.
All right, and is the defense okay with that?
Yes, submitted, Your Honor.
All right, then I do have the new 375 that was just handed out to defense counsel. Court will give that is currently constituted, okay?
Okay.
All right.
One moment, Your Honor.
Okay, we're back on the record. The court will give all the instructions that we went over before. I'm just going over the tagged instructions. Is there a request for the unjoined perpetrators instruction?
Yes, sir.
Any objection to that?
No, Your Honor, so long as it specifies that it relates to the incident involving Jane Doe number 4, which would be counts.
7 and 8?
Yes.
All right, and that refers to Matt?
Yeah, yes, sir.
Okay, I think that's appropriate, but we'll tailor the instruction to only reference count 7 and 8. All right,
Your Honor, that's Calcrim 373.
okay, want to submit that?
I can pull it up right now.
And I will give 375, which is the latest version the court just passed out. Then we can move on to, for some reason I had tagged Calcrim 1000, the rape by force or fear. I think that's fine in its current form, is that correct?
Yes, we didn't have an objection to that.
All right. And then finally, the last area is the special instruction regarding the statute of limitations. Late Friday, the court emailed its proposed instruction to counsel, citing two cases. One is People versus Yovanov, Y-O-V-A-N-O-V, as well as the Mabini case. The court suggested two changes. One is the definition of clear and convincing evidence, as well as whether or not to include language that evidence of the other type of sexual misconduct can by itself constitute independent evidence that would corroborate the victim's allegation. And the court included that in the email that was sent out. So, Mr. Owens, do you want to be heard on that?
No, Your Honor, the people agree with the court's drafting of the instruction and proposed it based upon the specific language that is contained within Mabini. I think that the court's clarification on the clear and convincing evidence standard makes sense so that the jury understands that it's more than preponderance, so we'll submit.
Okay. All right, we discussed this in chambers. Who wants to address this? I did read the brief that was submitted over the weekend. Mr. Watkins?
Yes, Your Honor, I did submit a brief on this. Our position is that this double definition of independent evidence is improper. I don't believe that the first definition of independent evidence, that part should be stricken and taken out of it. It has the second sentence here, that such sexual misconduct, if believed by you. That begs the question upon what standard does it have to be believed by you? And may standing, the second part of that sentence, may standing alone, that infers that evidence, other evidence may need to be accompanied by something else. I believe that whole definition is confusing and it's too suggestive. It's actually pointing the jury to evidence. So I believe that it shouldn't be a double definition of independent evidence. It should only be the single definition of independent evidence, which is evidence that is separate and apart from the testimony of Jane Doe. The jury then can use what other evidence that they feel independently, clear and convincingly corroborates her testimony, but they shouldn't be pointed to that particular evidence of prior sexual misconduct.
So you don't feel that independent evidence needs to be defined at all?
I think that the definition of independent evidence is evidence that is separate and apart from the testimony of Jane Doe, and we should just leave it at that.
I see, because that's what you had submitted, I understand. Okay.
Yeah.
All right, Mr. Owens?
Your Honor, I think that what the court proposed, or what's included in the court's instruction is an accurate statement of the law. It allows the jury to utilize evidence that's been presented at trial in accordance with the law, and if they so choose, and that it accurately instructs them on the burden of proof that's required in order to use that evidence. It states within repeatedly within the instructions that they must, in order for the people to prove something, it must be proven beyond a reasonable doubt. And Navini and Yavanov have both stated that if the trier of fact, the jury here, credits the testimony, believes the testimony regarding other acts evidence, then that standing alone is sufficient to corroborate the testimony of the accuser, Jane Doe number 4 in this case. And I think that that paragraph does nothing but allow them to use that evidence if they so choose, and ultimately find how to use that if they credit the other evidence presented.
Okay. Well, in People versus Yavanov, which was cited by Mabini, the court, the issue was squarely before the court. The court stated in Mabini, unlike the court in Yavanov, we must decide whether evidence of appellant's sexual misconduct against an uncharged victim standing alone constitutes sufficient corroboration. They went on to state that a trial is a search for the truth. Nothing in Penal Code Section 803G precludes the people from proving a corroboration element solely with evidence of a similar offense committed against an uncharged victim. Except as otherwise provided by statute, all relevant evidence is admissible. Evidence of similar offenses against an uncharged victim has a tendency and reason to prove a disputed fact that is of consequence to the determination of the statute of limitations allegation. Consequently, we hold that such evidence, if credited by the trier of fact, may standing alone constitute independent evidence that clearly and convincingly corroborates the victim's allegation. So that's why the court took that language directly from the court opinion, and the court will give that language over the defense objection. The court does not find that it is overly suggestive. It states that independent evidence may include evidence of such sexual misconduct, and that the court also put in there, if believed by you. So if the jury does not believe it, they're not going to consider it, and the clear and convincing standard is clearly stated within that instruction. So the court will give that instruction over the objection of the defense. You want to be heard further, Mr. Watkins?
Yes, another point, then the last sentence there, the last definition of independent evidence is evidence that is separate and apart from the testimony of Jane Doe. It shouldn't be the testimony of Jane Doe 4. It should be statements of Jane Doe 4.
Okay. We discussed this in chambers as well. The fresh complaint doctrine would encompass the statements but not her testimony. So in other words, the fact that she immediately reported to her friend and told her boyfriend and then told her husband and so forth, those are statements that could corroborate her prior assault. It's your position that it's still a statement of Jane Doe number 4 and should not be considered for purposes of corroboration?
Correct, and a fresh complaint only goes to the fact that the complaint was made. Here we're talking about independent evidence of the event happening, and it has to be something other than her word. And that's what the court needs here. Something other than her telling us that this happened. There needs to be some other corroborating evidence. A fresh complaint is nothing but her statement, her word. And so, yes, a fresh complaint goes into the fact that she did make a complaint, but the details of that complaint are irrelevant. And so, independent evidence is just basically something separate and apart from her statement, something other than her saying, this happened to me. And she could have told 10 people that this happened, but it still needs to be some evidence above and beyond, separate from her statement.
Okay, so you object to that last statement then, correct?
No, I only object to that last word, that word testimony. That word testimony should be changed to statements of Jane Doe versus the testimony of Jane Doe, because that seems to confine it to her testimony here on the stand. It should be her statements, whether made prior or in court or out of court.
All right, Mr. Owens?
Your Honor, I think the testimony accurately describes what the standard is for independent evidence under Penal Code Section 803. I think that what we discussed in chambers and what is clear from the case law is actually that it be separate and apart from the trial testimony of the witness who would be the alleged victim. The prior statements do come in under fresh complaint, but they also serve to be prior consistent statements to her testimony at trial. And I think that based upon the state of the law, the fact that there are additional witnesses who have testified to additional evidence prior conversations, the circumstances under which those conversations took place, the way in which she made these disclosures, the fact that she made these disclosures to those individuals, meaning someone she could trust and confide in, her husband, or the man who would become her husband, and then a prior boyfriend, and then her best friend shortly after the incident actually occurred, all served to confirm and corroborate that this act happened, which is the underpinnings of why 803 exists. I think that it does serve as independent evidence when it is separate and apart from the trial testimony, and statements would be overly expansive by somehow precluding them from thinking that they may be able to use the evidence presented in the form of Troy M. or Brandon Guillermo or Nicole Edwards. So I think the way the court has it crafted currently is appropriate and an accurate statement of the law.
Your Honor, briefly.
Yes, go ahead.
We have to look at the definition of the word independent. The definition of the word independent is something, this not dependent upon her telling the truth. We need something that's not dependent upon that. Her telling multiple other people, if she's not telling the truth, if she's lying to 10 people, it's still a lie. So it has to be not dependent upon her word. That's what the definition of independent is.
All right, when you look at the statute, it says there must be independent evidence that corroborates the victim's allegation. It shall be established by clear and convincing evidence. No evidence may be used to corroborate the victim's allegation that otherwise would be inadmissible during trial, and independent evidence does not include the opinions of mental health professionals. So they specifically preclude any mental health professional opinions in establishing independent corroboration. There is nothing in the statute that precludes the use of a fresh complaint. I understand the defense argument. It's still words of the alleged victim, and it's your position that whether it's trial testimony or a fresh complaint or a complaint to a boyfriend or someone immediately after, that there was a sexual act that was performed, that it should not be allowed for independent corroboration. I would note that there's a photograph showing those two together at the time as well, but the court believes that the fresh complaint doctrine was established to bolster the credibility of a sexual assault victim, and that policy for using it to consider the credibility of the witness gets to the heart of why the statute of limitations prohibition is included, because we want to make sure that there are credible complaints. And the fact that she did make the fresh complaint is evidence, and as the Supreme Court decision states, it does not have to be fresh. That's just one of the factors to consider. So the court finds that based on the policy behind the statute of limitations statute, which is Penal Code Section 803, which is consistent with the fresh complaint doctrine, that by analogy, it should be allowed to establish the allegation and is considered independent evidence. So over the objection of the defense, the court will leave the word as testimony and not change it to statements.
Can I make one more point for the record, John?
Sure.
The court just read that it needs to be evidence that, quote unquote, support her allegation.
Right, that's directly from the Penal Code section.
Right. Her prior statements are the allegation.
I understand that.
So it's not supporting the allegation, it is the allegation.
I understand.
Okay.
And I did consider that. Now it depends on the definition of allegation. Is it her testimony here in court? Is it the reporting of the crime? But based on the policy considerations for establishing the credibility of sexual assault victims, the court feels that it should be admissible. There's no case on this. I can't find a case on this. There is no case on this. But I do believe that the policy considerations will support the court's decision. So it's definitely noted that it's over your multiple objections. All right? So that concludes the jury instructions. Are you?
It's in 373.
Oh, okay. Did you print it out?
I don't have it. Oh,
I have it.
It should have gone through. Hopefully.
yes, I do. Got it.
Can you print it?
Yep. And then here are the other forms.
Thanks. All right, I did receive 373. Now we'll give 373 as well. All right, are there any other requested jury instructions by the people?
No, Your Honor.
Any by the defense?
No, Your Honor.
All right, I plan on pre-instructing today. We might go a little bit into lunch, but I'd rather finish the jury instructions by, say, 12:10 rather than have them come back at 1:30 for 10 minutes. Is there any objection to that?
No.
No, Your Honor.
Okay, let's bring them in. All right, we are back on the record, now meeting in the presence of the jury. I'm sorry it went a little bit long. We had a number of things to go over, and it took 10 minutes longer than I thought, but I appreciate your patience. Thank you for waiting. The record reflects that all jurors are present, all counsel, the defendant is present. All right, Mr. Carlos, Mr. Watkins, Ms. Barr, you want to call your next witness?
Yes, Your Honor. We call Summer Foster.
All right, Ms. Foster, you've already been sworn in, and you remain, actually, yeah, you remain under oath.
Okay.
So you can have a seat up there on the witness stand. All right, and whose witness is Mr. Watkins?
This is water, right?
That is
Okay.
water. That's right. Mr. Watkins, direct examination.
Thank you, Your Honor. Good morning, Ms. Foster.
Good morning.
Your Honor, I'm going to object to the display of the exhibit. There's no question pending.
Well, I'm going to ask a question.
Okay, you can ask a question. Just for the record, this is 183. Okay, thank you. Go ahead.
Is that you and your mother's GoFundMe page?
Objection compound.
It's my GoFundMe page.
The objection's overruled based on the answer.
On behalf of your mother?
Yes,
How much money were you seeking to get?
$50,000.
Nothing further, Your Honor.
All right, Cross.
Thank you. Can you please display, I believe it's Court's Exhibit 180.
183.
Okay. Thank you. I don't think it was identified. Did you create a GoFundMe page online last week?
I did.
Did you do that after you were interviewed by Court TV?
No, I had made the GoFundMe page after I had spoken with you. That was Friday, so I made it the night before I came in to testify, so that was Monday night was
Okay.
when I created it.
And when you say that you created a GoFundMe page, what is a GoFundMe page?
It's a crowdfunding service to, if you need help with something, like a lot of people do it for medical bills and, say like your car breaks down or something. You ask the public to help you fund some need that you have.
And did you feel like you had a need after finding out what had happened to your mother?
Objection,
Yes.
Your Honor, outside the scope.
Overruled.
Yes, I did.
Now, based upon what you testified to previously and what you, in terms of how you came to learn about what happened to your mother, did you feel as though helping your mother get out of town might be a good idea?
Objection, Your Honor, outside the scope.
Overruled goes to the motive for establishing the GoFundMe page. You can answer.
Yes, exactly.
Did you feel like she needed to be away from her attacker?
Yes.
Did you in fact state that when in the portion where you were requesting anyone who may want to donate to that cause in the post itself?
Yes.
Did you feel like, as you testified before, moving out of state may be a good idea?
Yes.
Now, the fact that you included the request for $50,000, where does that amount come from?
I was thinking about therapy cost, moving cost. Pretty much I was thinking, so the average wage of someone is like $50,000 in a year. So I was thinking to make sure that she is covered for at least a year while she settles and finds a job in the new state, I wanted to make sure she'd be covered.
You testified previously that your mother didn't know that you had come forward to the district attorney's office, right?
She did not.
Goes to the motive, Your Honor.
I'll allow it. Overruled.
She did not.
And did she know that you were actually then creating a GoFundMe page?
No, she doesn't know what this stuff is.
So you did this on your own volition, is that right?
Correct.
Did you do it to help your mother?
Yes.
Now, as far as any actual compensation or money paid, have you to date received any money from anyone?
No.
Did you include the fact that when you made the solicitation just out to the community, did you include the fact that you had no intention of attempting to bring any civil action against Mr. Winslow personally?
Yes, I said that in the GoFundMe. I don't recall if I said it on TV. I might have. I don't remember.
What I'm referring to as the solicitation, I'm referring to the posting.
Okay, then yes, I did.
And did you in fact state that you have no intent, that neither you nor your mother has any intention of attempting to get money from Mr. Winslow?
We do not.
Overruled.
We
The
do
answer will
not.
stand.
Thank you, nothing further.
Cross. Redirect.
Yeah. You said on Court TV that you and your husband are already planning on moving, isn't that right?
Correct.
So it's going to take another $50,000 to bring your mother with you?
Correct.
And you want money for a year's worth of wages, but your mother wasn't employed, was she? She wasn't working at the time of this, was she?
Objection 352 as it relates to the response.
I'm not.
Just hang on.
Okay, sorry.
It's okay. When there's an objection, I have to rule on the objection. The objection is what now?
Relevance in 352 as it relates to the specific employment.
Overruled. You can answer.
Are you speaking at the time of the attack or
Your mother wasn't working
right now?
She's not. She wasn't working at the time of the attack, was she?
I don't believe so.
And she wasn't working now. She's not working now, right?
Well, she has her seasonal job now. Yes.
That started when?
It started on this
Your Honor,
Friday.
Objection. 352 in relevance.
Well, I'll allow that answer to stand, but no further inquiry as to the type of job.
No. When you originally put this up, you were asking for $100,000, weren't you?
Yes, and then I realized that was way too much money.
And then you took the post down, right?
I did because I was receiving threats online.
Nothing further on.
All right, anything further?
No.
All right, can this witness be excused one more time?
Yes, Your Honor.
Okay, you are excused. Thank you very much.
Thank you.
Have a nice day. Next witness.
We call Officer Jacqueline Pacheco. She's up there.
You do solemnly state that the testimony you are about to give in the matter now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please have a seat at the witness stand.
This way.
And if you would, please state your name and spell your first and last name for the record.
Jacqueline Pacheco, JACQUELINE,
Thank you.
All right. Good morning, officer.
Good morning, Your Honor.
Thank you for being here. Direct examination.
Thank you, Your Honor. Officer Pacheco, how are you employed?
I currently work for the city of Carlsbad in the patrol division from 4 p.m. to 4 a.m.
Okay, how long have you been employed in that capacity?
I've been a police officer for about 4 years. My first few were with a different agency.
Okay, what are your duties now?
In the patrol division, our job is to respond to 911 calls and non-emergency calls. And I go out, I take my reports, I also do some self-initiated police work.
Did you get a call, a non-emergency call, to interview who we've been referring to as Jane Doe 5?
I did.
You're familiar with that person?
Yes,
Okay. Did you go out there and interview Jane Doe 5?
I did.
Okay. When you did that, did you have your body-worn camera activated?
I did.
Okay. Did she make a call into the police, or how did you come about interviewing Jane Doe 5?
Detective Johnson came to the Carlsbad Police Department, talked with my sergeant at the time, and said that there was a sexual assault that got reported into a Crunch Fitness, and we responded to her address to go investigate the call.
Jane Doe 5 didn't contact you, though, did she? Or
Not me directly or my department, no.
In fact, she didn't call it into the police, did she?
She did not.
Okay. When you interviewed Jane Doe 5, did you activate your body-worn camera?
I did.
Okay. And I'm assuming you discussed what had happened with her?
Yes.
Did she describe to you an incident involving a jacuzzi and another
Objection.
male?
Just a moment.
Leading.
Overruled, it's foundational.
Did she describe to you an incident that involved a jacuzzi and another gentleman?
Yes.
Okay. And when she told you, when she described that incident to you, did she describe leaving the jacuzzi?
When
some
she said
point?
she left the jacuzzi, she got out and went to a larger pool.
Okay. What did she tell you happened when she went to the larger pool?
She spoke with her husband.
What did she tell her husband?
She pointed out the suspect who's in the jacuzzi and said he's the one who was masturbating, and her husband identified the suspect as the football player.
What did he say specifically?
I'm sorry, what did he say or what did she say?
What did he say, the husband?
He said he's the football player, the one who has the problem, and they later identified him as Kellen Winslow.
And in fact, while you guys were interviewing them, you asked for a description of this individual, right?
I did.
And the husband, did he interject that he's a tight end?
Yes,
Okay. And that's a football position, right?
correct.
Did they inform you that they actually looked him up on the internet?
They said the husband identified him as Kellen Winslow. And she said that she looked him up at some point.
Okay. So they knew him by name, right?
He did.
And this was all before that they had ever even contacted the police, right?
Objection calls for speculation.
Overruled, well, no, sustained.
Again, they never contacted you to come take the report, did they?
Correct. They did not contact us.
Last question. You did a report in this matter, right?
I did.
And when you stated that Jane Doe 5's husband said he's the football player, the guy who has the problem, you put that in quotes.
Yes.
Why did you do that?
During my interview, at times when they say something, I'll write down what they said. I also have body-worn camera footage of the entire interview.
And you put that in quotes because that's exactly what her husband said, right?
That is what I heard, yes.
Thank you. Nothing further.
All right, Cross.
Thank you, Your Honor. When you spoke to Jane Doe number 5 and her husband, that would be Robert C., correct?
Correct.
That took place on the evening of February 26th of 2019, right?
Yes.
And when you spoke to them, that was after Detective Johnson had at least received some information about the incident and alerted the Carlsbad Police Department. Isn't that true?
Correct.
Now, when Detective Johnson spoke to your sergeant, you weren't necessarily privy to that conversation, were you?
No, I was not.
When he coordinated with you to obtain the statement of Jane Doe number 5, did he brief you, just generally speaking, about what information he had at that point?
He said it was a sexual assault case, and he planned on doing a photo lineup to ID the suspect if the victim didn't know who the suspect was. I myself personally was not familiar with the case. I'm not a huge football fan, so I didn't know really what was going on.
Sure, understood. And when you went there, was she, when I say she, was Jane Doe number 5 surprised to see you at her front door?
She was.
Did she, in fact, visibly look as though she was somewhat shaken during the entire interaction you had with her?
Yes.
When she was talking to you about what happened, did she get upset repeatedly?
She did. You could see, like, her voice was trembling during the interview, and she was visibly shaking at some points in the interview.
When she was shaking, did she still, at least in response to some of your questions, describe what Mr. Winslow had done on 2 separate occasions?
Yes,
Did she describe the occasion that Mr. Watkins just referred to as being the one in the jacuzzi?
yes,
And that was second in time, is that right?
correct.
And then she also described a prior occasion where he had rubbed his penis next to her while exercising on some machines on the second floor, right?
Correct.
Now, when she was describing those 2 occasions, did she tell you about when she told her husband about this?
During the first incident, she said she later told him, it wasn't immediately at the gym. The second incident with the whirlpool, she said she went in the larger pool at the gym and told him while they were still at the facility.
And when she was talking to you about what she remembers telling her husband and when, at that point she was also describing who might have actually done this, right?
Correct.
And did she in fact tell you that on the first occasion she had no idea who the person was?
She did not recognize the suspect until her husband identified him by name.
Right, and in fact that took place sometime after the act, correct?
Correct.
And when she was describing, or you didn't ask them how they knew who the suspect was, did you?
They voluntarily brought it up to me.
Right.
They told me from the start that they knew who was the football player.
And you weren't aware of how they came to learn that information or when, were you?
I don't know how specifically they identified him at one point in time in their lives, no.
When you interviewed them on the 26th, that would have been the day after they had reported this to the Crunch Fitness employees, right?
Correct.
And you weren't part of that conversation with the Crunch Fitness employees, right?
I was not.
You don't know whether or not the manager of the branch gave them any information about who had done this, do you?
I did not know about that conversation, no.
And have you ever personally interviewed Brad Moser?
No.
Did you interview Shelley Traub?
No.
So in terms of when they learned that the person who had done this, it happened sometime after the incidents, but then some before when you spoke to them, right?
Correct.
Thank you, nothing further.
All right, any redirect?
Briefly, Your Honor, when you're speaking with Jane Doe 5, she had mentioned that she told her husband after the first incident, right?
Yes.
And at that point, the husband also mentioned that he had seen that gentleman in the locker room, in the guy's locker room, right?
Correct.
Nothing further.
All right, anything further?
No.
Can this witness be excused?
Yes, Your Honor.
All right, did you work last night?
Not last night. I had a half a day off.
Okay, well, go home and get some sleep then. All right.
Thank you, Your Honor.
Have a good day. Thank you very much. Next witness.
The defense recalls Detective John Johnson.
All right, detective, you can retake the stand. You are still under oath. Okay, direct examination.
Good morning again, Detective Johnson. Good morning. I don't think you'll need your whole binder, but
hope not.
good to bring it anyway. Can you tell the jury if you know how tall is Kellen Winslow?
Based on my research, running his driver's license, standing next to him, I do believe he's a good 6'4".
6'4"? Is that right?
I believe so, yes.
And if you know, can you tell the jury how much he weighs?
I want to say 230, 240 pounds, but I can't be positive on that.
A range between 230 and 240 pounds.
I think that'd be safe.
And that's based on his DMV records?
I haven't looked at those in some time.
But that's his weight, to the best of your knowledge.
I think so.
Detective Johnson, did you interview Kellen Winslow on June 14th,
Objection.
2018?
Objection, hearsay.
That answer does not call for hearsay. It's a yes or no question.
Yes.
When you interviewed him on June 14th?
Objection, hearsay in 352.
Let's approach sidebar on the record. you ready? All set? Okay, we're now meeting in the presence of the jury. The last question that was answered by Detective Johnson was as follows. Detective Johnson, did you interview Kellen Winslow on June 14th? The answer was yes. That answer is stricken. The question is stricken. The jury will completely disregard that answer and not consider it in any way. Just treat it as though you never heard it. All right, next question.
Nothing else, Your Honor.
All right, Cross.
Thank you. So according to Mr. Winslow's DMV records, he's 6'4", correct?
I believe so, yes.
And he's 235 pounds, right?
He's up there, yes, sir.
And at the time that you contacted Mr. Winslow, he had some facial hair, correct?
Yes.
June 14th? Is that right?
Yes.
And the prior week on June 7th, you at least had seen Mr. Winslow, is that right?
Yes, I had.
Did he have any facial hair, if you recall, on that day?
Yes.
And would you describe Mr. Winslow as muscular?
As compared to who?
Well, let's just say, generally speaking, when you're talking about somebody's stature, would you consider him to be a fairly muscular individual?
I think most of our egos want us to think we're muscular. I think he's in very good shape, but when I think muscular, I tend to think about a bodybuilder. Lou Ferrigno would be muscular.
All right, now let me ask you in terms of your knowledge of Deputy Kyle Klein. Are you familiar with that deputy with the
Yes,
San
I
Diego
am.
Sheriff's Department?
Yes, I am.
How tall is he, if you know? What would you estimate his height to be?
Objection outside the scope, correct.
Sustained.
Now,
And he was here in court, so it's,
thank you.
the jury saw him for themselves.
Have you seen Mr. Winslow's tattoos?
Yes, I have.
Nothing further, Your Honor.
All right, anything further, Ms. Barr?
Yes, Your Honor. Detective Johnson, have you ever seen Mr. Winslow with his head completely shaved?
I've seen a photograph with his head shaved, yes.
And what time frame was that photograph taken?
I don't know. It's on the internet.
Do you think that it was taken within the last year?
I don't know the reference. I've looked it up on Google, and in the images, there's some shaved head photos of him.
Is that the image? You've never personally seen him with a shaved head?
Not to my knowledge.
Thank you.
All right, anything further? All right, thank you very much. You can resume your seat at council table. Any additional witnesses?
To the big rest, Your Honor.
All right, you want to offer 183?
Yes. Yes, Your Honor.
Any objection?
No.
Okay, 183 will be received and the defense rests, correct?
Correct.
Yes, Your Honor.
All right, is there any rebuttal evidence on behalf of the people?
No.
All right, ladies and gentlemen of the jury, you've now received all the evidence in this case. Just so you have some idea to scheduling, I'm now going to read you the law that applies to this case, and then we're going to hear closing arguments. We're not going to hear closing arguments today because there's no way we can get all the closing arguments in by the end of the day, and I want to be fair and not break up the closing arguments. So what I will do now is instruct you on the law. We're probably going to break a little bit early. We might go a little bit into lunch. I have a lot of jury instructions to read to you, and the court reporter will appreciate this. I'm not going to read them fast. So I will read the jury instructions to you. We're going to break for the day, and we're going to come back tomorrow morning at 9 o'clock, and you're going to hear the closing argument straight through. Mr. Owens will go first. Then we will hear from the defense. And because the people have the burden of proof, they get to argue first and last. So then he will have an opportunity to present his rebuttal argument tomorrow. But this case will go to you for deliberations tomorrow, all right? So with that said, I will now read the instructions to you that apply to this case. Just so you know, I'm going to send this entire notebook back with you to the jury room. So don't feel like you have to write everything down because all these instructions will go back with you. So members of the jury, I will now instruct you on a law that applies to this case. As I mentioned, I will give you a copy of the instructions to use in the jury room. These instructions that you receive may be printed, typed, or written by hand. Certain sections may have been crossed out or added by hand. Disregard any deleted sections and do not try to guess what they might have been. Only consider the final version of the instructions in your deliberations. As jurors, you must decide what the facts are in this case. It is up to all of you and you alone to decide what happened based only on the evidence that has been presented to you during this trial. Do not let bias, sympathy, prejudice, or public opinion influence your decision. Bias includes, but is not limited to, bias for or against the witnesses, attorneys, defendant, or alleged victims based on disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or socioeconomic status. You must follow the law as I explain it to you, even if you disagree with the law. If you believe that the attorney's comments in the law conflict with my instructions, you must follow my instructions. Please pay careful attention to all these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I happen to repeat it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be specifically defined in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not specifically defined in these instructions are to be applied using their ordinary everyday meanings. Some of these instructions may not apply depending on your findings about the facts of the case. Do not assume just because I give a particular instruction that I am suggesting anything about the facts. After you decided what the facts are, follow the instructions that do apply to the facts as you find them. Do not use the internet, a dictionary, a smartphone, a computer, or tablet in any way in connection with this case, either on your own or as a group. Do not investigate the facts or the law or do any research regarding this case, either on your own or as a group. Do not conduct any tests or experiments or visit the scene of any event involved in this case. If you do happen to pass by a particular scene, do not stop and investigate. You've all been given notebooks and may have taken notes during the trial. Actually, I think all of you took a lot of notes, and one of you needed another notebook. So you have taken a lot of notes. Of course, you can use your notes during deliberations. I always tell you to leave them here when you leave the courtroom, but you can take your notes back into the jury room. Your notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. In fact, I'm sure they're incomplete because nobody could possibly write down every word that was said, other than the court reporter, during the course of the trial. Now, if there's a disagreement about the testimony or any stipulations at trial, you may ask that the court reporter's record be read back to you. It is the record that must guide your deliberations and not your notes. You must accept the court reporter's record as being accurate. Please do not remove your notebooks from the jury room once you go back into the jury room. At the end of the trial, Manny collects your notebooks, shreds your notes. We don't read them. We don't look at them. They are for your complete personal use only. There's also, I think, this misconception that the court reporter prepares a transcript every day after the testimony. That's not true. Sometimes I get a note asking for all the transcripts to be brought back into the jury room. The transcripts in a trial like this take weeks to prepare, if not a couple of months. So we do not have the transcripts, but the court reporter, if requested, will go back into the jury room and read back the testimony if requested.
Your Honor, I apologize for interrupting. May we approach?
Yes. On or off?
I think we do it all.
Okay. All right. It is alleged that the crimes occurred on or about March 17th, 2018 for counts 1 through 3, on or about May 13th, 2018 for counts 4 and 5, and on or about May 24th, 2018 for count 6, and on or about in between June 20th, 2003 and June 21st, 2003 for counts 7 and 8, and on or about February 13th, 2019 for count 9, and on or about February 22nd, 2019 for counts 10 through 12. Now, the people are not required to prove the crime took place exactly on each of those days, but only that it happened reasonably close to those days. In this case, you heard from several Jane Does. There was Jane Doe number 1 through Jane Doe number 5. This name is used only to protect her privacy as required by law. The fact that the person is identified in this way is not evidence. Do not consider this fact for any purpose. It's only to maintain their anonymity. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, or brought here to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Now, whenever I tell you that people must prove something, I mean they must prove it beyond a reasonable doubt, unless I tell you otherwise. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. In deciding whether people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he's entitled to an acquittal, and you must find him not guilty. Evidence consists of the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Nothing that the attorneys say is evidence. In their opening statements a few weeks ago and soon in their closing arguments, which you will hear tomorrow, the attorneys have discussed the case and will discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they helped you to understand the witnesses' answers. Do not assume that something is true just because one of the attorneys asked a question that suggested that it was true. Now, during the trial, the attorneys objected to questions and moved to strike answers that were given by some of the witnesses. I ruled on the objections according to the law. If I sustained an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I ordered testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose whatsoever. You must disregard anything you saw or heard when the court was not in session, even if it was done or said by one of the parties or one of the witnesses. Now, during the trial, you were told that the people and the defense agreed or stipulated to certain facts. Those stipulations were marked as exhibits and will go back with you into the jury room. This means they both accept those facts as true. Because there is no dispute about those facts, you must also accept them as true. The court reporter, again, has made a record of everything that was said during the trial. If you decide that it is necessary, you may ask the court reporter's record be read to you, and you must accept the court reporter's record as accurate. Now, if you ask to have a witness's testimony read back, you're going to get the entirety of the testimony, both direct and cross. We can't just pick and choose small portions of the testimony to read back. You have to have the benefit of both sides asking questions, so you'll hear the entirety of the testimony if and only if you ask for readback. And just to let you know, sometimes it takes a while if you're requesting readback. It takes a while for the court reporter to go through her notes. She has to remove any sidebars, remove any objections, and remove any stricken testimony. So if you do send a note out asking for readback and it takes a while, don't think your request is being ignored. It is just being prepared. So you should continue your deliberations while you're waiting. Facts may be proved by direct or circumstantial evidence or by a combination of both. Direct evidence can prove a fact by itself. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of water, that testimony is circumstantial evidence because it may support a conclusion that it was raining outside. Now, both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state and acts necessary to a conviction, and neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact and issue has been proved based on all the evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to find the defendant guilty, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant is guilty. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions points to innocence and another to guilt, you must accept the one that points to innocence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. The people must prove not only that the defendant did the acts charged, but also that he acted with a particular intent. The instruction for each crime and allegations explains the intent required. An intent may be proved by circumstantial evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to that conclusion beyond a reasonable doubt. Also, before you may rely on circumstantial evidence to conclude the defendant had the required intent, you must be convinced that the only reasonable conclusion supported by the circumstantial evidence is that the defendant had the required intent. If you can draw two or more reasonable conclusions from the circumstantial evidence, and one of those reasonable conclusions supports a finding that the defendant did have the required intent, and another reasonable conclusion supports a finding that the defendant did not, you must conclude that the required intent was not proved by the circumstantial evidence. However, when considering circumstantial evidence, you must accept only reasonable conclusions and reject any that are unreasonable. As jurors, you alone must judge the credibility or the believability of the witnesses. In deciding whether testimony is true and accurate, use your common sense and experience. You must judge the testimony of each witness by the same standards, setting aside any bias or prejudice that you may have. You may believe all, part, or none of any witness's testimony. Consider the testimony of each witness and then decide how much of it you believe. In evaluating a witness's testimony, you may consider anything that reasonably tends to prove or disprove the truth or accuracy of that testimony. Among the factors that you may consider are the following. How well could the witness see, hear, or otherwise perceive things about which the witness has testified? How well was the witness able to remember and then describe what happened? What was the witness's behavior while testifying here in court? Did the witness understand the questions and then answer them directly? Was the witness's testimony influenced by a factor such as bias or prejudice, a personal relationship with someone involved in a case, or a personal interest in how the case is to be decided? What was the witness's attitude about the case or about testifying? Did the witness make a statement in the past that is consistent or inconsistent with his or her testimony? How reasonable is the testimony when you consider all the other evidence in the case? Did other evidence prove or disprove any fact about which the witness testified? Did the witness admit to being untruthful? And then finally, has the witness engaged in other conduct that reflects on his or her believability? Now, do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. People sometimes honestly forget things or make mistakes about what happened or what they remember. Also, two people may witness the very same event, yet see it or hear it differently. If you do not believe a witness's testimony that he or she no longer remembers something, that testimony is inconsistent with the witness's earlier statement on that subject. Now, if you decide a witness deliberately lied about something significant in this case, you should consider not believing anything that witness says. Or if you think the witness lied about some things but then told the truth about others, you may simply accept the part that you think is true and then ignore the rest. Now, the crimes and other allegations charged in counts 1 through 6 require proof of the union or joint operation of act and wrongful intent. The following crimes require general and criminal intent. Rape by force or fear is charged in counts 2, 4, and 7. Oral copulation by force or fear is charged in count 3. Sodomy by force or fear is charged in count 5. Rape of an unconscious person is charged in count 8. Willful cruelty to an elder is charged in count 11. And battery against an elder is charged in count 12. For you to find a person guilty of those crimes, that person must not only commit the prohibited act, but must do so with wrongful intent. A person acts with wrongful intent when he intentionally does a prohibited act. However, it is not required that he intended to break the law. The act required is explained in the instructions for each crime and each allegation. Now, the following crimes and allegations require a specific intent or mental state. Those are kidnap with intent to commit rape or oral copulation is charged in count 1. Indecent exposure is charged in count 6. Lewd act in public is charged in counts 9 and 10. The allegation of aggravated kidnapping is charged in counts 2 and 3. And the allegation of kidnapping is charged in counts 2 and 3. For you to find a person guilty of these crimes or to find the allegations true, that person must not only intentionally commit the prohibited act, but must do so with a specific intent. The act and specific intent required are explained in the instruction for each of those crimes and allegations. Neither side is required to call all witnesses who may have information about the case or to produce all physical evidence that might be relevant. The testimony of only one witness can prove any fact. Before you conclude the testimony of one witness proves a fact, you should carefully review all the evidence. If you determine there is a conflict in the evidence, you must decide what evidence, if any, to believe. Do not simply count the number of witnesses who agree or disagree on a point and accept the testimony of the greater number of witnesses. On the other hand, do not disregard the testimony of any witness without a reason or because of prejudice or desire to favor one side or the other. What is important is whether the testimony or any other evidence convinces you, not just the number of witnesses who testify about a certain point. During the trial, certain evidence was admitted for a limited purpose. You may consider that evidence only for that purpose and for no other. Now, you've heard eyewitness testimony identifying the defendant in this case. As with any other witness, you must decide whether an eyewitness gave truthful and accurate testimony. In evaluating identification testimony, consider the following questions. Did the witness know or have contact with the defendant before the event? How well could the witness see the perpetrator? What were the circumstances affecting the witness's ability to observe, such as lighting, weather conditions, obstructions, distance, and duration of observation? How closely was the witness paying attention? Was the witness under stress when he or she made the observation? Did the witness give a description, and how does that description compare to the defendant? How much time passed between the event and the time when the witness identified the defendant? Was the witness asked to pick the perpetrator out of a group or a lineup? Did the witness ever fail to identify the defendant? Did the witness ever change his or her mind about the identification? How certain was the witness when he or she made an identification? Are the witnesses and the defendant of different races? Was the witness able to identify other participants in the crime? Was the witness able to identify the defendant in a photographic or physical lineup? And finally, were there any other circumstances affecting the witness's ability to make an accurate identification? Now, the people have the burden of proving beyond a reasonable doubt that it was the defendant who committed the crimes alleged. If the people have not met this burden, you must find the defendant not guilty. Now, you've heard evidence of statements that a witness made before the trial. If you decide the witness made those statements, you may use those statements in two ways. One, to evaluate whether the witness's testimony in court is believable, and two, as evidence that the information in those earlier statements is true. A witness was allowed to testify as an expert and give opinions. You must consider the opinions, but you are not required to accept them as true or correct. The meaning and importance of any opinion are for you to decide. In evaluating the believability of an expert witness, follow the instructions about the believability of witnesses generally. In addition, consider the expert's knowledge, skill, evidence, training, and education, the reasons the expert gave for any opinion, and the facts or information on which the expert relied in reaching that opinion. You must decide whether information on which the expert relied was true and accurate. You may disregard any opinion that you find unbelievable, unreasonable, or unsupported by the evidence. Now, a defendant in a criminal trial has an absolute constitutional right not to testify. He may rely on the state of the evidence and argue that the people have failed to prove the charges beyond a reasonable doubt. Do not consider, for any reason at all, the fact that the defendant did not testify. Do not discuss that fact during your deliberations or let it influence your decision in any way. The fact that he did not testify cannot be discussed at all during your deliberations in the jury room and cannot be considered for any purpose. You have heard evidence that the defendant made an oral or a written statement before the trial. You must decide whether the defendant made any of these statements in whole or in part. If you decide the defendant made such statements, consider the statements along with all the other evidence in reaching your verdict. It is up to you to decide how much importance to give to the statements. Consider with caution any statement made by the defendant tending to show his guilt unless the statement was written or otherwise recorded. Now, the defendant may not be convicted of any crime based on his out-of-court statements alone. You may rely on the defendant's out-of-court statements to convict him only if you first conclude that other evidence shows that the charged crime was committed. That other evidence may be slight and need only be enough to support a reasonable inference that a crime was committed. This requirement of other evidence does not apply to proving the identity of the person who committed the crime. If other evidence shows that the charged crime was committed, the identity of the person who committed it may be proved by the defendant's statements alone. You may not convict the defendant unless the people have proved his guilt beyond a reasonable doubt. If the defendant tried to hide evidence or discourage someone from testifying against him, that conduct may show that he was aware of his guilt. If you conclude that the defendant made such attempt, it is up to you to decide the meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. If the defendant fled immediately after a crime was committed, that conduct may show that he was aware of his guilt. If you conclude that the defendant fled, it is up to you to decide the meaning and importance of that conduct. However, evidence that the defendant fled cannot prove guilt by itself. The evidence shows that another person may have been involved in the commission of the crimes charged in counts 7 and 8, and those are the counts involving Jane Doe number 4 from 2003. There may be many reasons why someone who appears to have been involved might not be a co-defendant in this particular trial. You must not speculate about whether that other person has been or will be prosecuted. Your duty is to decide whether the defendant on trial here committed the charged crimes. The people presented evidence that the defendant committed the offenses of rape by force or fear as charged in counts 4, and sodomy by force or fear is charged in counts 5. If the people have proved beyond a reasonable doubt that the defendant committed one or both of these crimes, You may but are not required to consider that evidence for the limited purpose of deciding whether the defendant acted with the intent to commit rape or oral copulation as required in count 1, which is kidnap for rape or oral copulation. In evaluating this evidence, consider the similarity or lack of similarity between the offenses and acts. Do not consider this evidence for any other purpose other than what I have defined for you in CalCrim Instruction 1191B, which I'll read to you shortly. Do not conclude from this evidence that the defendant has a bad character or is disposed to commit the crime. If you conclude the defendant committed the charged offenses and acts, that conclusion is only one factor to consider along with all the other evidence. It is not sufficient by itself to prove the defendant is guilty of the charged offense. The people must still prove each charge and allegation beyond a reasonable doubt. Now, you've heard evidence that Jane Doe number 4 had consensual sexual intercourse with the defendant before the act that is charged in this case. Those acts are alleged to have occurred on June 20th through 21st of 2003. And you heard evidence that Jane Doe number 4 had consensual sexual intercourse with the defendant before that act that's charged in this trial. You may consider this evidence only to help you decide whether the alleged victim consented to the charged acts and whether the defendant reasonably and in good faith believed that Jane Doe number 4 consented to the charged acts. Do not consider this evidence for any other purpose. All right, now I know this is a long list of jury instructions. I'm going to take a quick break here. We'll take just a 10-minute break. And when we come back, I'm going to give you the definitions of each crime, the elements for each crime that's charged in this case, counts 1 through 12. But I think it's good to take a quick break because sometimes it gets tedious reading these for a long period of time. So we will take a 10-minute break. Please remember the admonition. Don't discuss the case with anybody or form or express any opinions. We'll see you back here in 10 minutes.